Hello and welcome, everyone. We're really excited to have you all join us today. I'm here in Salt Lake City at the Case National Conference, which is a wonderful event for those of you who are special education directors and administrators. If you've ever had the chance to come, or if you ever get the chance to come, we highly encourage you to do so. But I digress away from the matter at hand, which is this webinar with a very special guest that we have today. We have Jonathan Reed, a gentleman who had a privilege of getting to know at a small symposium earlier this spring in Southern California. I can say this about Jonathan: he is knowledgeable about special education law, as knowledgeable as anyone you're going to come across. But I would also say this: he's interesting and he's compassionate, and he really cares about making a difference and moving special education forward. So we're in for a special treat today. He's going to talk about special education discipline. If we could move on, I just want to talk a little bit about this webinar today. I want to remind everyone, first and foremost, that we have closed captioning available. It's available to all of you who are watching this on Zoom. If you go to the bottom menu, you'll see the CC box with the live transcript feature. Just go there and activate that if you need your closed captioning. I also want to remind everyone that with this webinar, we will be sending a link, a transcript, and a certification of attendance for those of you who are here today. We'll be able to see who's all come to this live event. So want to remind you all of that. And with this presentation today, we'll try to get this introduction and all this housekeeping business out of the way so we can get into this presentation, which will be the bulk of what we'll see today. And I've given Jonathan the latitude to take as much time as he needs. He's got a lot of slides there. It is truly chock full of information. And if we have time at the end, hopefully there's 5 or 10 minutes where we can, have some Q&A and some discussion. But I want to remind everyone, if you have questions, please be sure to put them in the chat. And from there, we'll come back to those. We probably won't answer them in real time. We'll probably answer them in the Q&A portion of this presentation. So if we could move on to the next slide. For those of you who are attending this webinar for the first time, we are Illuma. Our goal is to make special education better. We want to make possible for kids to fulfill their potential. We specifically focus on mental health and related services solutions, primarily through teletherapy. We've been around for a few years now. We've got a lot of people working on this cause. We've been serving a lot of students. So if you'd like to learn more about Illuma, you can visit us at illuma.com. If you like this webinar, you'd like to learn when other similar kinds of webinars are coming, follow us on Twitter. You can see the handle there. At the same time, you can follow us on Facebook. Not only do we have webinars, we have all kinds of interesting content that is relevant to the cause of special education, to the cause of student mental health. Those are things that we all really care about. With that, we've got one other thing we want to mention on the next slide. If your school is in need of help for mental health, speech therapy, occupational therapy, school psychology, we know there are vast shortages in all of these areas. If your school is having a hard time getting the personnel you need, give us a call, schedule a consultation. You see a link right there. There's no obligation. There's nothing really crazy. But if you do it today and you use the promo code Illuma Webinars, we'll give you a $50 gift card that you can use for your classroom, whatever you need. So again, it's an amazing offer, amazing opportunity, and it's a really good company. So yeah, check out illuma.com/consultation. But let's get into the presentation. Let's talk about who we got today. This webinar is part of our special education webinar series. We've got a lot more of these. If you aren't signed up already, go to the link there, sign up for the webinars. I'll drop all this stuff in the chat when we're done here, but let's talk about Jonathan and this webinar today. Like I said, he's an amazing guy. He's an amazing attorney. He's been all over the map in terms of this. He's argued before the Supreme Court. He's a professor. He's an active attorney at an amazing law firm, F3, one of the biggest in the state of California, and they do special education law. They work with a lot of districts and help a lot of districts get things settled and solved. So encourage you, and I'll be dropping his contact information and URL for him and his firm. But if any of you have any, any kinds of needs for legal support, encourage you to go here first. I also love the fact that he's an educator first and foremost, has worked inside the schools and the brick and mortar buildings, and I think that means a lot. So one last slide. We're just going to give you a little bit of a summary of what you can expect in this presentation. Not going to go through it. I'm going to turn over the time to this amazing gentleman. Without any further ado, here is Jonathan Reed.
All right, thank you, George, and I appreciate the introduction. And you're right, I do believe strongly in public education, and I believe in the mission of Illuma. As we come across these last 2 years, we're just seeing a whole population. You all know we're seeing a whole population of students with no experience in school, and another population of students who have been without their support structure for the past few years. And so we see so many children with mental health needs that we need to get on top of and need to address. And along with that, we're seeing behavioral issues like we've never seen before. And so this presentation is intended to focus on discipline, but I will touch a little bit at the beginning on just how the IDEA, the Individuals with Disabilities Education Act, addresses behavior generally. But really, it's the disciplinary arena that I want to focus on. I'll say in advance, this is not an area that I recommend that you try to memorize. It's great to have a cheat sheet. We have some prepared. If you're interested in those, feel free to contact me. And we'd be happy to get those forward. But it is somewhat complicated. And so I'm going to try to break that down into some digestible chunks so that if we come across situations where we do need to discipline special education students, we're prepared to do that. Okay. The Biden administration has been very forthcoming about their concerns regarding mental health of public school students. But their Department of Education has also been very explicit about concerns regarding behavior and how that's manifesting with suspensions and removals. The divisions, OSERS, OSEP, OCR, have each issued guidance regarding their concerns about maintaining a positive school environment and implementing, procedures like RTI or MTSS to try to address behavior proactively and positively before it results in discipline. And so if you look at, I'll try with all of these slides to include a citation at the bottom if you're interested in looking at this information a little bit more. But they have been telling us that they want our campuses to be addressing both mental health issues and behavioral issues proactively through positive behavioral interventions before we go to the disciplinary arena. But sometimes we have to do that. We do have an obligation to maintain the safety of our campuses, and so it's imperative that we know what steps we need to go forward in addressing behavior. Okay, so what does the IDEA say about behavior? Really not much. Essentially, what it says regarding behavior generally is that if it impedes learning, if the IEP team determines that it impedes learning, we got to address it. Okay, how you address it, that's up to the IEP team. And I'm not going to spend too much time on that. I will say, though, that it's important to think about behavioral intervention in the same manner that you think about the continuum of least restrictive environment. Meaning that if we do determine that behavior impedes learning, we got to be thinking, can we address these needs in the general education environment so that we're not removing children from a general education? And then from there, we need to think, do we need behavior goals? Do we need certain accommodations or modifications? Do we need an aid, or do we need to conduct a behavioral assessment and develop a BIP, a behavioral intervention plan? Or if none of that is satisfactory to the team, do we need to talk about a specialized placement? Now, I will say I'm presenting from a legal perspective, not an educational perspective, even though these can intertwine. And I will tell you that there are certain behaviors where immediately you have to go right to a change of placement. The behaviors are so significant that they do have a potential effect on the safety of the student, of the children who are around the student, and the staff. And so I don't want to say that you have to exhaust all of these interventions before getting there. But there are also a lot of situations where a child with a disability will present a behavioral issue, and the school site typically will go straight to the change of placement before contemplating whether a lesser restrictive environment could have been workable with maybe some supports or assessment or intervention. Okay, so that's what the IDEA says generally about behavior. And then the other area that it addresses behavior is within the context of discipline. And this is an area where you have to monitor essentially days of removal for disciplinary reasons throughout a school year, because your timelines are going to dictate what your obligations are. And the timelines are not all consistent. And so what I would recommend is that if at each school site you have somebody who's in charge of monitoring removals, so that you know where you're at throughout a school year with the amount of removals that exist. But there's essentially two questions to try to make this understandable. The first is, can you remove an individual from a public benefit because of their disability? Okay. In our case, public school is a public benefit. And if you remove them because of something related to their disability, well, that's discrimination. So part of our obligations, part of the procedural safeguards in special education discipline is ensuring that we're not discriminating against the student by removing them because of something related to their disability, something that's a manifestation of their disability. Okay. The second question is, in special education, who is in charge of changing a student's placement? And maybe who is the wrong term. Maybe which entity is in charge of changing a child's placement. Okay. And I think you probably all know this. That's an IEP team decision. So if we're going to change a placement outside of the IEP process, we need to make sure that we're going through, again, some procedural safeguards, because essentially what certain suspensions and definitely expulsion is the district unilaterally changing a child's placement. Okay? So we have to know when a change of placement occurs, when the removals accumulate, so that they, in effect, become a change of placement. Okay, those are the two questions that are kind of our guide, our themes throughout the rest of this. All right. So a long time ago, when I was in high school, there was a case that went up to the Supremes, Honig v. Doe. And the Supreme Court was addressing the question of when does a removal or a series of removals amount to a change of placement. And the Supreme Court relied on some guidance from the Office for Civil Rights, OCR, to land on 10 days. And after that, the legislature liked it so much, they adopted that 10-day guideline into the language of the IDEA, and the federal regulations followed that in clarifying what our obligations are hovering around these 10 days. But it wasn't, it's not so simple, because if you have removals that over 10 consecutive days, well, then it is simple, right? You're over 10 days, and if 10 days is the deadline or the timeline for a change of placement, you know where you are. But what do you do when removals accumulate throughout a school year to over 10 days? Is that a change of placement? Is it not? And that's a little bit nebulous, but we'll try to walk through that. But the byproduct of this, and this was first kind of spelled out in the Department of Education's regulations in 1999, that there are essentially 4 categories of removal. They're under 10 days. They're 10 days that removals that accumulate to over 10 days, but we're not going to consider them a change of placement. They're removals that accumulate to over 10 days, and we are going to consider them a change of placement. And then removals over 10 consecutive days, which are quite easily a change in placement. So let's go over quickly. And what I'm going to do is this is kind of background information on special education discipline generally, and then we're going to get into a little more of the details through 10 frequently asked questions. Okay, so under 10 days, you treat the child just like a general education student. I get at least 4 or 5 calls every year from an attorney saying, little Billy was suspended for 3 days. He has attention deficit disorder. It's his behavior, his malfeasance was related to the attention deficit. You cannot suspend the child for 3 days. And my response is always the same. It really doesn't matter if it's related to the disability or not. Under 10 days of removal, districts are allowed to treat the child just like they would a general education student. General disciplinary rules can be implemented under 10 days. But it's important to keep in mind that you may be getting calls with people saying, you can't suspend because my child's in special education. This was related to their disability. And, we want to be understanding, but we also want to say, general disciplinary rules apply. If anything, that gives us some time to figure out how to appropriately address the behavior. So hopefully they don't reoccur. Okay. Category 2, these are changes of placement. These are removals that accumulate throughout a school year, but we're not considering them to be a change of placement. And I'll get into how to distinguish the two to the best that I can. But the key here is that if they accumulate to over 10 days, and we're not considering these to be a change of placement, on the 11th day of removal, the child is entitled to services as determined by his teachers and service providers. And essentially, somebody needs to go and consult with the teachers and service providers and figure out what the child should be doing starting on the 11th day of removal. There's no obligation to have an IEP meeting. There's no obligation to have a formal meeting or anything like that. The child just needs to be able to get work, to be able to participate in general education, and also to progress on goals. Okay. And then type 3 and type 4 are removals that accumulate to over 10 days, and they are forming a pattern or over 10 consecutive days. And this is where there's a change of placement. So if we get back to our two themes, we're going to have to determine whether or not this change of placement is related to the disability or not. Okay? And since we're going to essentially be circumventing the IEP process, if we're going to go forward with these removals, we have to make sure that the child is still going to get a FAPE after the 11th day of removal. And so for the type 3 and the type 4, the IEP team is going to have to decide what services the child gets starting on day 11. And then not technically an IEP team, but oftentimes this occurs during an IEP meeting. We have to get together and determine whether the behavior was a manifestation of the child's disability. Okay, and depending on the answer to that, that affects what our obligations are. Now, keep in mind, there's two timelines that are implicated here. And I'll explain what those are, but they're not necessarily the same. So that's a little bit of a complicating factor. Okay, so first question, how do you distinguish between a type 2 and a type 3? Well, what the IDEA says is we look at the length of removal, the total time that this child has been removed, and the proximity of the removals to determine whether or not they form a pattern. And if any of you are interested, I tried to include citations. You'll see it says 34 CFR 300.356. You can Google that and you'll come up with the regulation. Those are regulations from Title 34 of the Code of Federal Regulations. And those spell out all of these rules that I'm talking about. Okay, I find that this guidance is kind of worthless. What I tend to recommend is that if you're an experienced educator, you'll know when there's a series of behaviors is a pattern, right? You know, if a child gets in a fight in September, gets suspended for 5 days, and then maybe the following February is caught you know, with something they shouldn't have, and they're suspended for another 5 days. And then maybe at the end of the school year, they are suspended because they were truant. I don't know what it is, but they're far apart. They don't, you know, they're not real similar. Probably not a pattern there. On the other hand, you know, if a child is, you know, selling some pot in a little baggie in September, and then maybe is, you know, in November is caught doing the same thing, and then in December gets caught with, you know, holding some marijuana. You know, obviously those are related. They form a pattern. You know, it's the same general area of offense. And so that would definitely probably be a type 3. But, you know, the key is to trust your instinct, and when in doubt, just treat it like a type 3 and provide the procedural safeguards. Okay, and, you know, I recommend that, again, you appoint somebody to be in charge of keeping track of these removals throughout the school year, because that's really what tells you what you need to do. Okay, so if we have a type 3 or a type 4 removal, what are our obligations? Okay, well, essentially, we have to notify the parent. Okay. We have to attach a copy of their procedural safeguards. Okay. We have to implement services starting on the 11th day of removal, and we have to conduct a manifestation determination. Okay, so let's unpack that a little bit. Not later than the date of the decision to take disciplinary action is made, we have to provide notification of what that disciplinary action is and provide the procedural safeguards. So that should be in writing. It has to be in writing. And you need to essentially let the parents know what's going on. And at any stage, if they take an issue with what we're doing, those procedural safeguards will let them know how to enforce their rights. Okay. Now, on the 11th day of removal, the child's entitled to a FAPE. Okay. And the IEP team has to decide prior to the 11th day of removal what that FAPE is going to be. It doesn't have to be, obviously, if the child's suspended or expelled. The FAPE at the school where the child's typically getting services, but the IEP team has to decide what services the child is going to get and where the child is going to get those. And just for your information, I get asked this all the time. This is not an actual IEP team. I scanned the internet probably around 2003 or 2004, looking for pictures of what may look like an IEP team. And I thought this was a fine looking group of people. And so they've been my IEP team for about 16 or 17 years, I think. Okay. Now, the manifestation determination. This is where you're determining whether a behavior is a manifestation of the disability. And the first thing that you'll notice is that the deadline for doing your manifestation determination is 10 school days from the decision to extend the removal beyond 10 school days. Okay, so if a child's accumulated removals, maybe they're at day 8 and it's February, and you've decided to suspend the child for 5 days, okay? When that decision is made to extend the removal beyond 10 days, you have 10 school days after that to have your manifestation determination. Okay? In California, for general education students, nobody can be suspended for over 5 days unless typically the principal meets with the parent and decides at day 5 to extend the suspension into an expulsion. So in that situation, your decision would be made 5 days after the behavior, and so you would have 10 school days after that meeting to have your manifestation determination. And I get calls at least 3 or 4 a year saying, you know, the child's been removed for 12 days and we haven't had our manifestation determination. Did we blow it? Can we still engage in the disciplinary process? And I'll ask, you know, when did you make that decision to remove beyond 10 school days? And a lot of times the deadline is still fine. Okay. Now, since you have to have an IEP meeting prior to the 11th day of removal to determine what services are provided on day 11, you probably don't want to have multiple meetings. So it's a good idea to collapse all of that. And most of the time, we'll have the manifestation determination as part of the IEP meeting prior to the 11th day of removal. But kind of an interesting fact, you'll see here, it says that the manifestation determination team consists of school district, parents, and relevant members of the IEP team. It's not technically an IEP team that conducts the manifestation determination, but since at an IEP meeting, you're going to have these individuals, you might as well do your manifestation determination at that meeting. You need to review the records and relevant information provided by the parents. There have been a number of cases across the states where school district personnel have done this review on their own, and then they show up at the manifestation determination meeting and announce that they've done this records review and they've checked the box on their manifestation determination form. And if you've excluded the parents from that review, that could be a procedural violation that could and has in the past convinced a judge to reverse an expulsion and expunge a child's record of references to an expulsion. So you want to make sure that you're conducting this review at an IEP or a manifestation determination meeting, which is likely going to be an IEP meeting. And then you're gonna, these are probably on your forms, you're gonna ask whether the conduct was caused by or had a direct and substantial relationship to the student's disability, or whether the conduct in question was a direct result of the district's failure to implement the IEP. And this is something that changed substantially when Congress last reauthorized the IDEA in 2004, because before that, the questions essentially came from the insanity defense in criminal law, where the questions were, did the child have the ability to control their behavior, or did they understand that the behavior was wrong? And also, you know, if you were not, if a district was not implementing the IEP in an aspect of the IEP totally unrelated to the behavior, that might end your manifestation determination. So, but, you know, after Columbine, quite frankly, the pendulum had swung where Congress was much more interested in keeping campuses safe. So they made the questions somewhat more nebulous, and they restricted any implementation problems in the IEP to aspects of the IEP that might directly relate to the behavior. You know, if a child, if the IEP team had offered weekly counseling and the team was not implementing it, you know, that might end your discipline. Or if there was a behavioral intervention plan and staff were not trained or didn't know about it, and were not implementing the behavioral intervention plan, and the child got into a fight, well, that would be a problem at the manifestation determination stage. Okay, this slide is probably impossible to read, but I'll just kind of go over it with you. If the behavior is a manifestation of the disability, that means it's related to the disability, our discipline stops, right? To continue to remove the child would be considered discrimination. Okay. What we're obligated to do is look to see if the child has a behavioral intervention plan. And if the child does, we have to tweak it. We got to tweak the bit. And we have to edit, you know, or whatever you're going to do with the behavioral intervention plan to make sure you're addressing what the behavior was. If the child does not have a behavioral intervention plan, then we have to conduct a functional behavioral assessment. Go out and do the behavioral assessment. We'll get parent consent for the assessment first, and then reconvene when it's done. And based on that, we need to develop a bit. But our discipline does not go forward. That's not to say that the IEP team can't, outside of the disciplinary process, determine that the placement's no longer appropriate and either provide behavioral interventions in that IEP or change the placement as part of that IEP. But the disciplinary removals end. Okay. If the conduct is not a manifestation of the disability, at that point, you treat the child like a general education student. And depending on what your hearing process is for expelling students, disability should not be related to it. Oftentimes, we'll have expulsion hearings where parents or their representatives will say, this child is disabled, you know, you can't expel. And really, their opportunity to make that argument is through the manifestation determination process. And if they disagree, you've given them their procedural safeguards. They can file a request for a due process hearing. But the expulsion hearing itself is not the opportunity to do that. And we need to educate whomever in our school district is in charge of those hearings, so that they know that that's not a factor in that decision. Okay. If parents have revoked consent to special education altogether, and we know that they have the right to do that, are they entitled to the procedural safeguards? Nope. You know, if they've pulled their child out of special education entirely, a child's not eligible for special education, we can treat the child like a general education student, even if we know that they have a disability that qualifies them for special education. Okay. Next questions have to do with partial day removals or in-school suspension. So we've developed in-school suspensions, and this would be consistent with what all of that guidance is from the feds regarding trying to minimize suspension and expulsion as an outcome for students. But if we have in-school suspension programs where they can continue to work on their goals and continue to receive their IEP services and to participate in the general curriculum, then those probably are not going to count as days of removal. You'll see there's a third factor here, whether they have the same opportunity to participate with general education peers. I'm not saying that you have to import a proportionate share of general education students into your in-school suspension program. And I'm not aware of a case where, because of that issue, that factor, it has counted as a day of removal. It may be impossible, but really the key here is that they have the opportunity to work on general education curriculum and their goals. And if they do have that, then those may not count as a day of removal. Okay. Bus suspensions may count as a day of removal if transportation is a related service described on their IEP, right? And oftentimes we don't think about, removals in that sense, but if we're providing bus transportation as a related service, child gets into a fight on the bus and the school side or the bus driver says, you can't be on the bus for 5 days as punishment, those could be days of removal. If we're faced with that situation, we ought to try to provide transportation through some alternative means. I've seen districts use Uber or Lyft. I've seen them use taxis. I've seen them offer reimbursement to parents, mileage reimbursement. And if we're able to do that, then we have a pretty good argument that those removals would not be considered disciplinary removals. But if we don't, and they're not getting it, that could be a problem. Okay. Students sent home early for disciplinary removals can count as a day of removal, especially if they're missing special education or related services at the end of the school day. There's been some debate about whether you can round up or, maybe you get a half a day of removal. In my opinion, I think if the child is not participating in all of their IEP services that day, a judge more likely than not is going to consider that a day of removal. Okay. Interim alternative educational settings. Let's spend a few minutes on this. This was something that Congress also came up with in 2004 as a way of giving districts the unilateral right to ensure safety at their campuses. And essentially, what Congress gave us was the right to unilaterally remove a child from their placement, to change the placement to an interim alternative educational setting for up to 45 days if they've engaged in one of these three activities. They've carried or possessed a weapon, they've possessed or used illegal drugs, or sold or solicited a controlled substance, or they've caused serious bodily injury. Okay. If any one of those three things occurs, you can unilaterally remove the child to an alternative setting for up to 45 days, regardless of whether it's a manifestation of the disability. Now, important caveat, that allows you to remove the child to a different placement, but that does not absolve you of the responsibility to still conduct a manifestation determination and provide the parents notice and their procedural safeguards and all of that. You still need to comply with those requirements. Okay. Now, in addition to that, separate from that, you can file a request for a due process hearing to ask a judge, an administrative law judge or a hearing officer, to remove the child for up to 45 days. And the standard for this is whether you can prove that the child's behavior is substantially likely to result in injury to the student or others. And sometimes this is a lot safer option because, as we'll see in a few slides, the serious bodily injury standard for the unilateral imposition of a 45-day placement is pretty high. And if a child is maybe just getting into a fight and they've perhaps been violent on a number of occasions, but they've never really caused serious bodily injury, then it could be safer to go this route because all you need to show is that the child's substantially likely to result in injury to him or herself or others. Right. And at any time, you could go into court and get an injunction. And in my experience, special education hearing officers oftentimes, we all live in the weeds of all of these procedural obligations and all of these IEP requirements. And sometimes we forget, about the real world. And in my experience, judges who are not involved in special education are a lot more likely to just simply conclude, is there a safety issue at all? And if there is, I'm going to impose an injunction. And so I've had cases where we've decided, the behavior is not serious bodily injury, but we're not sure if an administrative law judge in the world of special education is going to agree with us. So let's just go into court and get a temporary restraining order. And in my experience, the judges, their analysis is quite simple. Is there a safety risk or not? If there is, we're done. Now, regarding the unilateral 45-day placements, the federal the United States Code tells us what a weapon is. It's the definition's right here on this slide. I'm always fascinated as to why there's an exception for pocket knives with blades of less than 2.5 inches. And my guess is that this code section is entirely old. And there must have been a lot of students who used to come to school every day. Perhaps they're all ex-Boy Scouts with little pocket knives. And so this exception exists in the law, but you can see various cases. Scissors can be a weapon. Those scissors that preschool students get, probably not a weapon, and I'm not sure that they can really cut anything anyway. A pencil or a paper clip, courts have found that those aren't weapons. Illegal drugs, I think, self-explanatory. I would say, though, that if a child has a prescription for a drug, that's not illegal. But if that child sells that drug to someone else who doesn't have that prescription, actually, it doesn't matter if they have the prescription or not. If they sell it to somebody else who that becomes an illegal activity, or if that other child has that medication that's legal for someone else but not legal for that student, that could be an illegal drug that subjects that child to discipline. And then serious bodily injury. The courts have just decided for some reason that the standard here is really, really high. And so essentially cases from around the states where some violent behavior has not been serious bodily injury, a broken nose, kicking a principal in the knee, kicking a teacher's shin, where she did go to the doctor and describe the pain as a 7 out of 10. I'm guessing that if you are kicked in the shin and you go to the doctor, based on this case, you're going to want to make sure that you're describing the pain as higher than a 7. but we had a case a few years ago out of here in California where a 6-year-old student headbutt a teacher. She had to have 3 doctor visits. She was out of school for a week. And even coming back was involved some serious issues. And a judge did find that that constituted serious bodily injury. Okay. You can, if there are multiple episodes, you can have more than one 45-day placement. You can't unilaterally extend a 45-day placement, though. But if the 45-day placement's at the end of the school year, you can continue it at the beginning of the next school year. Question number 8, when will a hearing officer remove a child to an interim alternative educational setting? As I mentioned before, it's when the child engages in behavior that makes it substantially likely that the child will injure him or herself or others. And the one thing that a judge can do is extend that 45-day placement if you petition the judge to do that at the end of that period. So that may be a route that you go through. And sometimes a parent will file against the district if they disagree, maybe with a manifestation determination. So you have litigation already, and that may affect your choice to go ahead and cross complaint to get the judge to place the child in an interim alternative educational setting as well. Okay. Now, there are situations where general education students assert these procedural safeguards. And those situations involve where a district is held to have knowledge that the child might be disabled. Okay. There used to be a saying, if your child is suspended, request an assessment. Okay. That doesn't necessarily mean that you had knowledge prior to the behavior that the child may have a disability. What the federal regulations tell us explicitly is that knowledge exists if a parent has expressed concern of a need for special education, the parent has requested an evaluation, okay, or teacher or other personnel have expressed concern about a pattern of behavior. There used to be a 4th category prior to 2004 that just said if the behavior suggests that the child might have a disability. But again, in 2004, Congress was trying to make it easier for districts to remove students. And so they got rid of that 4th factor. And these 3 factors are a lot more, there's much more of a bright line standard as to whether or not they've occurred. If the parent expresses concern, it has to be in writing, and it has to be to supervisory or administrative personnel or to one of the students. It can't be, an email to the aide or something, kind of informal like that. If teachers or district personnel have expressed an interest, it does have to be to the special ed director or supervisory personnel. And if those exist, then it's in all likelihood we should expedite an assessment. And if the child is eligible, apply the procedural safeguards and conduct a manifestation determination. Or even if we determine that the child we did not have knowledge previously, but the parent has requested an assessment at the same time as the notification of the disciplinary action, we have to decide, is there enough here to trigger our obligation to assess? And if so, you might want to suspend your disciplinary removal, your suspension or expulsion, give an assessment plan, expedite the assessments, and then if the child's eligible, apply the procedural safeguards. And if not, then, you have fresh data that you have a general education student and you can discipline the child as a general education student. Okay. And final question, when can a parent appeal? A parent can request a due process hearing if they disagree with a manifestation determination, or if they disagree with the interim alternative educational setting or the placement. They're entitled to an expedited hearing. My experience is the judges will not continue these cases or reschedule them. They are compelled by law to have the hearing within 20 days of the request and issue the decision 10 days afterwards. And this is an important note. Stay put applies. Okay. And oftentimes, in the world of special education, the term stay put is used quite liberally. But really, it's a term that technically only exists during the existence of litigation. But, I've had cases where a child is engaged in extremely violent behavior. There's a manifestation determination. The team determines it's not a manifestation. The parents file a request for a due process hearing. They file a motion for stay put, and the district places the child back into the last placement. And once the child realizes that there's a population of students who might want to retaliate, they might be more amenable to removing the child somewhere else. If that is the situation, you may want to think about either implementing the IEP at a different location, which might still comply with stay put, or even going into court and getting a restraining order against implementation of stay put. Okay? So really quickly, special education discipline in a nutshell. If we're looking at discrimination and we're looking at a change of placement, there's 4 types of removal. The first 2 types are not a change of placement, so we treat the child like a general education student. For type 2, we got to talk with the teachers and service providers to determine what services are necessary on day 11. If we are going to change the child's placement by removing them over 10 days, either cumulatively or consecutively in a school year, we have to convene an IEP meeting to determine services on day 11. And we also have to, within 10 school days of the decision to remove beyond 10 school days, conduct a manifestation determination. And if it is a manifestation of the disability, discipline ends. But if it's not, then we treat the child like a general education student. That is special education discipline. It's the Reader's Digest version. I think I did it in 45 minutes or so. But if there are any questions, we still have some time. I'd be glad to take them right now.
Well, let me jump back into the fray here. We do have a few questions here. The first one is from Norris Senhart. Not sure how to say that. But she did ask, can you be able to conduct an FBA without the student if you have enough disciplinary data and teacher's notes?
In my world, which is presenting those types of cases to judges, the answer would be no. Because at this point in time, as far as assessments are concerned, I'm finding that the judges are weighing actual observation more heavily than the other aspects of assessment, which could include review of records, interviews, or standardized test instruments. Those observations appear to be key. And so, it doesn't have to actually be the behavioralist who's conducting the assessment. They can assign other people in the classroom to collect that data who are observing the behavior. But I wouldn't rely entirely on a review of records to determine what the function is of the child's behavior.
Okay, and it looks like I've got a couple of questions for you, and then we've got just a couple of minutes here. But one of the things I always like to look at the big picture, and I look at the law is such a unique thing. It's always changing and evolving. And where do you see all this going, Jonathan? What changes are the most necessary that need to take place that haven't happened yet? And which changes are the most imminent? And what do you see on the horizon as you look ahead?
As I look ahead, it's crystal clear to me that the U.S. Department of Education, probably your state departments of education following in the federal footsteps, and also Congress, if they ever get together to reauthorize the IDEA, are expecting a couple things. They're expecting us to look at behavior proactively, so that we're addressing behavior before they get to a level where it's resulting in discipline. And so whatever steps you can take at your school sites to implement interventions that occur early and are based on positive behavioral interventions, that's key. And also, as we come across our COVID years, we're experiencing children with, profound mental health issues, profound behavioral issues, and IEP teams have to be looking at those. And if you are, deciding on behavioral interventions, those cannot be interventions that exist in some file somewhere that no one knows about. They have to be interventions where everyone at the school site, not only the teacher, but maybe the recess staff, the administration, they're trained on positive behavioral interventions for that particular child.
Well, that's awesome. Well, we're almost at time here, but I have one more question, and it's just more
Sure.
pertaining to you. Obviously, you're an accomplished attorney, but you're also a distinguished presenter and publisher. And so I'd love for you to tell us about things that you've worked on that you think people should know about relative to this subject, and maybe some things that you're working on now and will be sharing. And what do you have coming up? I know that you presented LRP and some of these other things. So if you've got some other things you would like to promote, now would be your best chance.
All right. Well, I appreciate that. I do think that even though the Congress hasn't reauthorized the IDEA since 2004, it was profoundly clear when they did back in 2004 that they were very concerned about this separate culture that is developed in the world of special education. And we're seeing that, with concepts like RTI with respect to academics, but we're also seeing that with respect to behavior and even mental health issues. And where I think the law is going is to increase the expectation that these types of proactive interventions are available in general education, right? Before we even go the special education route. I think that's going to be huge. It's going to be very explicit.